Good morning, Ms. Hassim. Good morning, Mr. Premhead.
Morning, Chair.
Morning, Chair.
Thank you. We are all ears.
Chair, we, before today's witness takes the stand, we have an interlocutory application that has been brought by Mr. Sulaiman Karim, and it's for his evidence to be provided in camera. And Mr. Premhead will address the Commission on that application. And I believe there's a preliminary issue that Mr. Premhead would also like to raise with the Commissioners, if we could begin there. Thank you.
I also have a preliminary issue I wish to raise with your preliminary issues, but perhaps let's hear your preliminary.
Thank you, Chair, and for the indulgence of going ahead of you. My learned friend is correct. This is an application that my client's main evidence be given in camera. My concern at the moment is that even though the directive says that it will be given in an open session at the college, as we are here today, my concern is that if the in-camera application is argued in front of all and sundry, and I say that with all due respect, bearing in mind that there are cameras here at the moment, and I don't know whether there is a live stream or a live broadcast, I have to raise the possibility that the very argument of the in-camera application would render the application itself and any subsequent determination nugatory because of the consideration of it being in camera. And I must admit, when I read the original directive that said open session at the college, I assumed that that meant we would have an open session in the way that we are physically here, but that it would still be determined in camera pending whatever outcome is to be made, as opposed to how we had asked for the reasons canvassed in the in-camera application that it be done virtually or at a different venue and so on. And so I just have to register my concern with all due respect that the very substance of the application we're going to debate, which will determine how my client gives evidence, is potentially going to be pointless by virtue of the fact that we may have a live proceeding or live television proceeding that goes out. And may I just say this, I can understand that if the Commission is ultimately against me on the in-camera application, that there can be publication of everything ex post facto, because in that instance there would have been a final substantive determination on whether it should be in camera or not be in camera. But if we argue the in camera in open, as we are doing at the moment, and I repeat my concern about live television proceedings, then that creates the prejudice. And you would recall, Chair, that in the notice of motion filed by the applicant, if you have the paginated bundle in front of you, if you look at paginated bundle 3, prayer 2, the prayer 2 notice of motion, with all due respect, I think covers a situation that we find ourselves in where the very request for that proceeding itself is to be in camera. Otherwise, the outcome would be rendered nugatory. And so those are my submissions as to my preliminary concern. Thank you, Chair.
Thank you, Mr. Premhead. Mr. Premhead, I'm not sure that I follow you with regard to the point that the outcome and what's basically sought will be rendered nugatory. I just don't get that, because what Mr. Karim seeks is that the hearing of his evidence should be in camera.
Yes.
If he succeeds, how will this open session have rendered that nugatory?
Well, that's the exact dilemma, Chair, with all due...
And also, perhaps, let me add this.
Yes.
All, if I'm not mistaken, my colleagues will correct me, and perhaps even the evidence leaders, all applications for in-camera hearings have always been heard here in open session. And a good few of those were found to have substance, and the actual hearing of the testimony was then in camera.
Yes.
So I don't know what makes this one stand out, and for the argument that the whole thing will be rendered negative. I just don't follow it. I just don't follow it.
I followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats, and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the consequence of that doesn't detract from the fact that my client, based on what he says in the affidavits, is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does not, or rather does, undermine the very purpose of the in-camera, which was to protect that disclosure when he comes back to the commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted and that he's still giving the evidence, with the effect that the threats are going to materialize again, with all due respect, because it effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Karim, wants the public to be under the impression that he will not be testifying, or what exactly
No,
is the point?
that's not the case.
What then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was being conducted in camera, in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight given to the people outside of this room that the in-camera application was made, and if it was granted, then the public knows that Mr. Karim ought to have testified on the 9th and the 10th, that he might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the
Agreed.
difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these proceedings were in camera, On the 9th and 10th, if the commission is with me and grants the in-camera in substance, then whoever is threatening Mr. Karim and the public at large would be left to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be, insofar as Mr. Karim's appearance at the commission is concerned. That would not release Mr. Karim from the obligation to still give evidence, which he would give, but it's the details around that evidence and the session itself that would be protected and offer him an interim modicum of protection where he says, I'm being surveilled and I'm being threatened even before I give the evidence.
I don't quite see the difference in substance to what I said earlier, which was that, so Mr. Karim doesn't want the public to know that he will testify at one stage or another. The various options or possibilities or permutations you referred to boil down to, or at least part of it boils down to what I said, which is that he does not want the public to know that he will testify.
Yes, but that's not because he has, the case he's pleaded in front of the commission is not because he doesn't want the public to know, it's because of the threats that he's received.
But part of what you said, says exactly what I said.
No,
of the various permutations you gave, part of it says exactly what I said.
I accept that, but we
Yes.
also have to accept that there will be parts of your report, for example, that might be subject to certain confidentiality regimes. There might be evidence that is in your final report that is subject to certain confidentiality regimes which the public at large would not know about. So it's not as though Mr. Karim, with all due respect, is asking for something unique or specific to him that the Commission's rules itself does not contemplate. It's to, the Commission is being asked to strike the appropriate balancing act between making the witness testify, which Mr. Karim accepts, he has to testify, obviously, but at the same time protecting him or offering him a measure of protection that neutralizes or potentially neutralizes some of the threats that he is receiving. With all due respect, I haven't taken an instruction from my attorney at the moment, but just speaking frankly, if this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested. I've heard what you've said to me, Chair, but I must obviously put my client's position regarding what is happening at the moment and how that potentially prejudices him in light of the relief that he sought under 4.2 of the Commission's rules.
You earlier said you may already be touching on the merits. Perhaps what I'm going to raise also touches on the merits.
Is this the preliminary concern now, Chair?
No, but no.
Are we still on the preliminary?
I'm still on your preliminary.
Okay.
Preliminary.
Got you,
yes,
Chair. Got you,
yes,
Chair.
Yes. How exactly, everything being conducted in the manner in which Mr. Karim suggests, how will the evidence then be dealt with in practical terms afterwards? For example, you even referred to the final report treating the evidence in a particular manner and perhaps even the public not having access and so on. So I'm raising what I'm raising
Yes.
in the context of that submission.
I accept that, yes.
How will the Commission handle the evidence, assuming that the application is granted?
Yes.
Yes. I'm thinking, maybe let me just add, I'm thinking, for example, the evidence may say something about people who may either themselves on their own want to respond, or in respect of whom the evidence leaders may want to lead evidence that counters whatever Mr. Karim may have said. So how does all of this get handled?
I accept.
Because those people will have to know.
No, of course. And
content
I'm
of
not
the evidence.
suggesting that a case be conducted against them in their absence or without their fair trial rights being protected. as you know, Chair, my client is particularly keen on his fair trial rights. It would be ironic if he's attempting to... The Minister of Finance is trying to phone me. That must wait until later. I apologize. I'm sorry, Chair, go ahead.
Yeah. Oh, sorry.
Sorry, Chair, what I was going to say to you is that we obviously have no difficulty with whatever accommodation has to be made to facilitate the fair trial rights of any other witness who may be impacted by my client. But what we know, and that's foreshadowed with all due respect in Rules 4.2 and 4.3 of the Commission's rules. But what we know in practice from cases like Bryden and Helen Suzman Foundation in particular, which in your previous capacity, Chair, you would be very well familiar with. There are particular circumstances where the disclosure of evidence in a particular context is subjected to a confidentiality regime that appropriately balances the interests in the evidence coming to the court, or in this case, the tribunal, the inquiry as the tribunal forum, so that it can apply its mind to all the evidence and do its job, but also that the court, and here I would say the Commission of Inquiry under those rules that I have quoted, has an equal power to impose a degree of, and I'm hesitant to use the word secrecy regime, I'd rather use confidentiality regime, that protects interests that are implicated if it was just conducted in the ordinary manner, which is the open justice default position. And with all due respect, Chair, in Helen Suzman Foundation, building off the commercial case of Bryden, you were at pains to explain that that the kind of regime that Mr. Karim is asking for, including the kind of regime that you would be entitled to impose in terms of the rules for what happens in future, is the appropriate balancing exercise where constitutional rights are implicated. And because my client has claimed that there's a threat to his life, there's a threat to his family, there's a threat to his businesses, there's a threat to his employees, this is the appropriate instance that the Commission, and through you, Chair, must consider its own rules which enable such a balancing exercise, and then your powers to give appropriate directives to achieve that balanced outcome. That's what we would say. Of course, my attorney tells me that there are other witnesses Karim's obligation to come here and to tell the Commission what the Commission wants to know and be subjected to questioning by the evidence leaders and the Commissioners. It's about the threat that has been identified and what the Commission does in recognition of that threat and to exercise its powers we would submit it should do to protect him in light of that threat. That's really where we are, Chair. Thank you. I apologize if that was a very long answer.
No, understood.
Thank you, Chair.
Can I? Thank you. Maybe on just that last point, to start there, that other witnesses, including Mr. X, have testified in camera and arrangements were made to protect their evidence. That's not applicable here because all the decisions about witnesses testifying in camera is based on the testimony that they are going to give. You bring a completely different application at this stage.
Yes.
You say the application itself to be heard in camera should be in camera. So yours is not, I mean, those other cases don't apply to you here, one. But you, in your engagement with the chair, you speak to, you want to be heard in camera. There's actually two legs to your application. You want this very application to be in camera because you don't want it to be known why the reasons that he's seeking to be heard in camera. Well, they are out there now.
It's too late now. Yes, absolutely.
And as an aside, I would have thought ordinarily a person would want it to be publicized that the concerns that your client has, that there are people who are making threats against me, they would want the light to be shown on those who are making the threats on them so that they know the world is watching. I would have thought that's what your client would want to happen. But more importantly for me, you have two parts to this. The second part is you want the papers, including this application. So we are not yet in the merits. This very application that you are before us about and that you are arguing about, you wanted the papers to be shared only amongst a defined number of people in the commission. You say the chairperson and commissioners, the evidence leader designated to lead, Mr. Karim, the commission's appointed legal team, the secretary, Mr. Karim, Mr. Karim's appointed legal team, and the commission's official transcriber. You haven't said why you want to restrict. You want the commission to restrict who has access to these papers. And I've tried to read your papers. I don't see a case made for it, including for this leg of the application. I mean, it seems like your client is wanting something that, certainly I've never encountered anything like this, and he doesn't lay a basis why only these seven, or people in these seven categories should have access even to this, even before you get to his statement on the merits. Or the application to be had in camera, just even this preliminary issue. Can you just explain what's going on? I really don't understand this application. And on what legal basis does your client think he's entitled to have to prescribe, as he's doing, about who should have access to his papers? One. Two, the legal basis for him to seek to be heard in camera, his application to be heard in camera. I've never, ever encountered that, and I don't see a legal basis for it set out in your submissions, but also the factual allegations, if there are any factual allegations here. I don't understand this application, Mr. Kermit.
May I respond? Thank you, Chair. Commissioner Baloy, thank you. May I start with the first question about the prescribing of the access? That is rooted in the understanding of the applicant of Rules 4.2 and 4.3, read with Rule 11, which on our reading, 4.2 says, in an appropriate case, the chairperson may make an order that a hearing be held in camera or via electronic means. In such a case, the chairperson shall specify in the order those persons who shall be permitted to attend the hearing in camera or by some other means. Then with 4.3, at the request of the witness whose evidence is to be heard in camera or meru motu, the chairperson must order that nobody may, directly or indirectly, disclose the identity of the witness who is to give the evidence in camera, and then read with Rule 11, which is the so-called catch-all rule, which gives the chairperson the procedural right to determine issues not otherwise prescribed in the rules.
Yes, what I'm trying to understand is this defined list. I understand the rule. I know what the rule says and the powers that it gives the chairperson. What I want to understand is, when your client says only the evidence leader dealing with the matter should have access to this application that we are concerned with right now, on what basis does he assert that kind of
Yes.
of request?
Yes.
We have a whole team of evidence leaders.
Yes.
We have investigators.
Yes.
Right? You know that.
Yes.
There is no explanation.
Yes.
Why those should not
Yes.
have access to this application.
Yes.
And I can put to you that, at least in my reading of your application, there's nothing confidential
Yes.
about it. He's not, your client is not disclosing any confidential matter. The best he does is to suggest that the threats are confidential. That's because that's the only basis on which he's seeking for this first leg to be heard in camera, and all he speaks to is the threats. So he's asking for the threats to be kept confidential. Why can that not be shared with the rest of the staff of the commission? Why shouldn't the staff be aware that there are these threats that are that he's relying upon?
Yes. Let me immediately accept that on the strength of the affidavits as prepared and submitted in front of the Commission, there is no direct engagement with why the list curtailed in Schedule A is presented in the way it is presented. I accept that, and I'm not going to dispute that, because that would be a hopeless cause. But I hope that, Commissioner Baloy, you can see that there is a relationship in the exercise that is being done in Schedule A with what is set out in the rules that I've just read to you, in the sense that where in an appropriate case there is an in-camera consideration, the chairperson can make an appropriate directive to limit access as to who can or cannot have access to those proceedings and the papers. So
yes, I'm not having that debate with you.
No,
I know that's what the rules say,
Exactly.
and we have used the rules.
Exactly.
What I'm struggling with, or what I don't see,
yes,
is how that gets to be applied, or how your client relies on that,
Yes.
given what he has
yes.
set out in the
And
papers.
that's why I started by clarifying, by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content of the application is threefold. Number one, Mr. Karim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Karim specific matters. And so the Commission might in and of itself have its own Chinese walls that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the Commission, where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Karim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Karim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely, so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Karim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the Commission that they may not distribute. Or in fact, he doesn't trust the Commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the Commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the Commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes? That's my question.
It is a yes, but
Okay.
I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes in the sense that, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the commission that that lack of trust arises. And I'm being very guarded in my language in making that point because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the commission to the public?
Does it involve breaches of confidentiality?
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Pramit, or what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the commission, it does not include a complaint that the commission has disclosed what he asked to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified.
That's
not what you're complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
But Mr. Karim can't make his own rules.
No.
There was, from where the commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is
that.
actually totally unacceptable, Mr. Premier.
With all due respect,
Mr. Karim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD, it's not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
But with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I
intervened
continue?
twice, my colleague was still asking you. Yes, please go on.
May I
Premier.
respond to you, and then Commissioner Baloy, subject to the Chair's authority, of course, if you can re-put your question to me, because I'm now dealing with what the Chair says.
Yes,
I apologize for that. But Chair, it's very important because when the application was launched, what was explicitly raised with the Commission staff and the evidence leaders is a request that this entire application would be disposed of. This very in-camera application that we are asking for today would be disposed of by the 25th of February, which was before the statement was due, so that my client would know what his position was come the 27th regarding the filing of the statement and whether that was going to be in camera and then the hearing was going to be in camera or not in camera, because obviously the determination of the in camera might have also triggered my client's request to file a confidential affidavit with the Commission. And so on the 18th of February, my client doesn't only say, please bring this to the extremely urgent attention of the chair so that a determination is made by the 25th before our statement is due. He says you can even dispose of this entire matter on the papers. We don't need an oral hearing because this is an extremely urgent matter. The issues are fairly narrow and we want an expeditious outcome so that we know what our client's position is. And with all due respect, what happens on the 18th of February from the Commission, we get a one-line email saying, we confirm that same is in reference to the application, will be relayed to the Secretary and the evidence leader shortly, and we will revert with formal instructions in due course. Nothing is heard from the Commission from the 18th, 19th, 20th, 21st, 22nd, 5 days. And now you must remember, of course, that the statement deadline is coming nearer and nearer. And what we then do on the 23rd is we write to the Commission on the 23rd to say, please can you advise us what the delay is, because our statement deadline is approaching. We might be wrong in the way that the chairperson puts it to me that it's not for Mr. Karim to determine, but we need some clarity from the Commission, the chair in particular, as to what the next steps are here. And so, with all due respect, Chair, when I talk about these threats emanating, it's not as though my client had, by the time his statement fallen due, not only launched an application where formal relief was sought in respect of the delivery of that statement, correspondence was repeatedly sent to the Commission staff and the attorneys asking that this matter be dealt with extremely urgently and in an expedited fashion. And my client also waived with respect the very right to a hearing that we are having here because he wanted to know what his position was by the 25th so as to what to do on the 27th. And where I say that those threats from the Commission are unconscionable, and with all due respect I speak subject to the chair putting me back in order if I'm out of order, is that the Commission in its subsequent letters after the 27th don't even engage with the fact that it's due to them that the entire matter hasn't been disposed of on the timetable that might have been extremely urgent for understandable reasons, but where we had asked for a ruling. So why I'm saying that those threats are unreasonable in the circumstances is not because it was Mr. Karim acting of his own accord. It was Mr. Karim at every stage saying to the Commission, place this in front of the Commissioners, get me a determination by the 25th so I know what to do by the 27th. And when the 27th came and went, we hadn't heard anything. We only received the answering affidavit on the 24th. So, Chair, with all due respect, I hear what you say to me, and I hear your admonition regarding what I said about the Commission's threats. But there's a factual context that's important to bear in mind as well, and that is that Mr. Karim sought the assistance of the Commission to let him know what to do by the 27th.
You say you hear what I say about what you referred to as threats, and yet you proceeded to say what the Commission did is unconscionable. I take strong exception to
I'll withdraw that statement, Chair.
kind of language.
I'll withdraw that statement.
Thank you. What you've said raises two issues. What you have submitted raises two issues. The first one is, you asked the Commission to keep all documents, affidavits and all relating to this matter, confidential. The first issue is, I have no idea why Mr. Karim would not have wanted to file his statement if, in the face of his request, and there being no basis for him to believe that the statement would not be kept confidential. That's the first problem I have. And then secondly, my point about there having been no change with regard to the deadline, yes, I've heard what you say, but the bottom line is the deadline was never changed. The deadline stood. So on those 2 points, I still have difficulties with your submissions.
Chair, I don't know if you want me to respond, or
Yes,
those were
you're
your
free to.
concluding
Yes.
remarks?
No. You're free to respond.
No, thank you, Chair.
Mr.
I
President.
appreciate that.
Yes.
On the first issue about not be kept confidential, I'm not going to rehearse what I said. All I'm going to point out, Chair, is the first time that was given unequivocally, that the main statement would not be disclosed prior to the determination of the in-camera, was only finally clarified on the 3rd when the directive came out. That was on the facts after the statement.
Just on that, why right from the beginning, instead of tying the filing of that statement to the hearing of the interlocutory application, why did the applicant in the first place not make the simple request that that statement should be kept confidential?
But with all due respect, we did, and that's addressed, that's in the founding affidavit and the notice of motion, and it's in the covering letter. And that's part of the difficulty we have here, is that we place all of this in front of the Commission, we ask for an expedited decision and an outcome, and instead of being told or being told by the Commission, yes, your concern about the main statement is taken care of, it will be held in confidentiality until such time that the in-camera is determined, we don't hear anything. The first time that the Commission puts up an answer is on the 24th, and incidentally, it doesn't deal with the request regarding the in-camera. If the Commission was able to give that undertaking by the 24th when it filed the answering affidavit, then we wouldn't be having this debate, because by the 27th, my client would have filed the statement.
All 15 pages of it, yes.
Yes, absolutely. Whether it's 15 pages, 3 pages,
I know.
100 pages.
I'm just, yeah.
Whatever the case might be, he would have been able to file because the undertaking would have been given. The only time that my client then was given the assurance is when the 3rd comes down, the 3rd directive comes down. And look at what happens. When the directive comes on the 3rd, and the directive says, you must file your statement by the 4th, and you must file it by 9 o'clock, and it will be kept confidential, the statement is filed, no difficulty. So with all due respect, it's a bit unfortunate that my client finds himself in this position in circumstances where he's not in control of these things, and a concern is raised for determination that affects the filing of the statement but is being dealt with in the way that I've just explained. So that's on the first issue regarding the main statement. The second issue, Chair, which I've now forgotten because I've written a note here that says deadline, but I have no idea what that means.
I think I've forgotten also, but probably...
As long as you forgot, Chair, that's fine. That's okay for me.
Probably it was that. But the bottom line is that the deadline was never changed.
Yes.
Whatever may have been going on in Mr. Karim's mind, the bottom line is that the deadline was never changed.
But that's it. But you see, that's, with all due respect, it's that catch-22 dilemma that my client is caught in.
Do you know what judges usually say? They say that when counsel says, with all due respect, deep down inside they're saying, what the hell?
Chair, I've never been accused of using such soft language in my entire life, so I'll take that. I'll take that.
Mr. Karim, you wanted me to reformulate my question, to re-put it to you. I thought you had answered my question, but then you went on to muddy it with the threats and the filing of the statement, and all of that was said about it. But I had the first part of your response was, you are not saying that there's been a disclosure of information submitted to the Commission by Mr. Karim, which he had marked to be confidential. You are not saying the Commission has landed that kind of material in the public domain.
Yes, we're not saying that.
Yeah, that's what I wanted to clarify with you. And then then my next question, which I may well now ask, it's now out through you, right, in the engagement with the chair, why you want this application to be in camera. We've had many slip-ups like that from legal representatives, where they do seek something and then they are the ones that actually disclose that which they're asking for.
Yep.
Or that they're arguing. So it's now in the public domain, the reason that you want this application to be in camera. Is there still hasn't the issue become moot? At least this first part. Hasn't the issue become moot and we should just go ahead and hear that part of the application?
Chair, my attorney is whispering something to
That's all
Chair,
right.
through you. May I just take the instruction? Thank you. Thank you. Commissioner Baloy, before I forget your second question again, I'll still go back to the chair, but in response to you, Commissioner Baloy, yes. That's exactly why when I started, I said I have to place my concern on record that if we have this debate in the manner that it's happening, the very purpose of the in-camera would be rendered futile. And so when I started my remarks, that's why I needed to record that, because I was caught in a catch-22. Either I sit here silently and look at the three of you and the three of you look at me and I don't say anything, or I have to address what I need to address, but my claim for confidentiality and in camera is then materially prejudiced by that. And it's that very conduct, with due respect, that I'm saying has caused the prejudice that my client complains about in the affidavit itself. I mean, it's that famous Sutherland judgment, BDFM versus SAA, that once confidentiality is lost, it's difficult to get it back. And that's the exact position my client finds himself in. So I accept that it might have been through my own doing, but it was under the cover of recording the concern I had regarding the futility of us proceeding then in the way that we had.
I guess it may become necessary for us for completeness, to pronounce on your argument for confidentiality. It may well be, without changing anything, because as you seem to agree, the issue has become moot. We might as well go ahead with this application, but then the chair may have to pronounce on this claim for confidentiality, whether there was a case for it in the first place.
Yes, may I say, Commissioner Baloy, it's like one of those interlocutory disputes that arise in a main proceeding where the determination of the interlocutory then has the unforeseen consequences that it has. And given that as we walked in, we were then subject to live television cameras, that's the catch-22 that I was caught in, but also that my client was caught in. So even though the application is theoretically still in front of you, because as the chair reminds me, we're still only dealing with the preliminary point, I accept the consequences of the arguments that we've just had and we've just made. May I just go back, Chair, the second point that you had made, which we had both conveniently forgotten, but then unfortunately you remembered, about the deadline. I hear everything that the chair says. I would only ask that the chair bear in mind that there was a request for a ruling before that deadline came and went, so that my client would know what to do in circumstances where he says, I'm asserting a right of confidentiality. If I give my statement, that will render my asserted right of confidentiality nugatory. And on the other hand, if I don't give the Commission what they want, I am then liable to coercive force by the Commission in the enforcement of its rules. So yes, the deadline is what it was, but it's not without the prior context of, please tell me what to do before that deadline comes so I know what my position is. Thank you, Chair. May I just check if there's... Oh, I apologize, Commissioner Kumalo.
Mr. Permit, you could have just said, here is my statement, is ready, please treat it confidentially. There was no need for all that drama. You wanted to consult with your attorney and then we will ask our questions after, so... Yeah.
Thank you very much, Commissioner Khumalo, for the indulgence. We're ready to
I don't
proceed.
want us to debate the point I made, because I think the preliminary point has become, I think you should just leave that prayer. Prayer 2 must just be abandoned. And when you deal with prayer 3 and 4, I will tell you what my concern is.
Before the merits, may I? Did I get the impression that, but for our engagement, you were done with your submissions, Mr. Premier?
On the preliminary, yes, I think it's only fair that Ms. Hassan
Yeah,
gets an opportunity
that's where I want to go to.
respond.
That's where I
Absolutely.
want to go to.
Although I
Are
don't
you
think-
accepting you abandoning 2 so that we don't need to debate?
I would prefer the Commission make a ruling against me rather than abandoning it.
Okay.
All right.
Thank you, Chair.
Ms. Hassim?
Thank you, Chair. I mean, in the light of the questions that came from the Commission, I can be brief just on the preliminary point. I think we should probably just get straight to the merits, because as Commissioner Baloy says, this issue of the preliminary point has become academic. After the first, I think it was only after the first minute or two of my learned friend's address, we strayed right into the merits. And so part of what's been debated, in fact, concerns the merits of the application. But even though, that should be the end of it, I would like to say 1 or 2 other things. The first is that my learned friend says that he did not understand the session today to be a session in which it would be a public one. And I must say that's hard to understand in the light of the directive of this court on the 3rd of March.
Commission?
Pardon me, of the Commission. I must wear my other hat. In the light of the directive of this Commission on the 3rd of March, which stipulated that it would be heard in open session. Now, even if that were not a live broadcast, what it could not be understood as is to be a session that would be closed to the public. So even if it were not a television broadcast or live streaming on other platforms, this was going to be an open session, open to the public and open to the media. So any reporting or any coverage, photographs, anything would still be permitted in an open session. So it doesn't aid my learned friend to say that, understanding of what an open session was that it would be somehow closed and that it would only be perhaps the legal representatives and the commissioners. On the statement, let me say, the statement, it's always been the practice of the Commission, and there's never been a breach of confidentiality thus far, not in relation to this witness or in relation to any other witness on the side of the Commission staff or evidence leaders. So that is not something that ought to have given rise to some suspicion.
But on that, I can imagine that Mr. Premier will probably say neither he is instructing attorney nor Mr. Karim knew that procedure.
That was, and let me say that there has been some clarification in that regard, that statements that are given, the practice is witnesses provide statements to the Commission before they appear before the Commission to provide their oral evidence. It's only once the witness testifies that the statement becomes public. So it would only be on the determination of this application, which would then determine what kind of procedure follows next, that the statement would become public. That's the second thing. The third thing I want to say is that in relation to the perceived threats of the breach of the ruling of this Commission, it is important that witnesses understand, and the legal representatives, what the requirements are of the Commission and the status of rulings that are given by the Commission. So it wasn't in the nature of a threat. It was in order to advise the witness that you now are in breach of the ruling of the Commission, and it's important, and a duty, I would add, of the evidence leaders to protect the processes and the integrity of the processes of the Commission. So a ruling that says that the statement is to be provided on a certain date is that. It cannot be amended without the Chair's reconsideration of the ruling, which would require an application, and there was none such application in that regard. And finally, on the statement, it really wasn't tied to the determination, it wasn't conditional on the outcome of the in-camera application, right? Because the statement is for the purposes of providing evidence to the Commission. So I just wanted to make those remarks with regard to the statement to clarify that. But I've also said what I've had to say about the ruling on the 3rd of March, that this was to be an open session. For me, that's where this preliminary debate would end. And so, and then given that the ship has sailed, we should probably proceed into the merits of the application. Thank you, Chair.
Thank you, Ms. Hassim. Mr. Premhid, one last. Yes. Any response, Mr. Prem?
Yes, three very brief ones, if I may. In respect of the first point made by my learned friend about her understanding of the directive, with all due respect, it's not her understanding that matters. It's what the Commission makes of the application and the request for the ruling beforehand. And that's why the ruling was made beforehand. The request for the ruling was made beforehand, so my client wouldn't find himself in the exact position he finds himself in at the moment. On the second point, my learned friend, in fact, actually makes the case for us because her exact words were, it's the determination of this application that would thereafter determine the disclosure of the main statement. And that's exactly why, not only in the correspondence and in the notice of motion, but in the founding affidavit, before that statement was due, the direct application was made at paginated page 12 of the pleadings bundle, paragraph 27, I humbly request that the Commission determine this matter as one of urgency. This is because my witness statement is due on Friday, the 27th of February, 2026. If a determination is not made about my hearing evidence in camera, and with that regarding the witness statement by this date, then my witness statement will be made available to the general public, defeating the purpose of this application. If that was wrong, they filed the answering affidavit on the 24th of February. They could have made the undertaking or given the clarity on the 24th of February that the statement wouldn't be disclosed.
But why would he have thought, and I think that's the point that Ms. Hassim was making, that his statement would be made public before he testified? On what basis does he have that concern to a point where he doesn't abide or comply with a clear directive?
But that's because, as the chairperson foreshadowed, is that my client doesn't have knowledge of the inner workings of the Commission.
It's not about the inner workings. It's about what, you see, what he has done, and I have to deal with this by way of an example. He has made a claim. He's making a claim for confidentiality based and for in-camera, based on the threats he has received, but matters that he says are reported in the public domain. He's made references and he's annexed stuff that is in the media. So he's relied on matter that is in the public domain. I'm asking a question like that there is nothing, he knows nothing about the processes of the Commission, as you rightly say. He doesn't know our internal workings, but again, he has nothing from the public space that is a basis for that concern about his statement being made available to the public. He makes it up. He makes it up, and on the basis of that fear that he's making up, he then says, I'm not going to file my statement until you give a ruling because it might go into the public, when there's absolutely no basis whatsoever, no factual basis for him to raise that kind of concern, and therefore not to abide a ruling that says you must file by a certain date. So it's not an answer to say, I guess what I'm doing is I'm saying, how reasonable is this fear about my statement will be disclosed to the public when there's absolutely no factual basis for it?
I accept that, and you've already heard me in my opening remarks that, to the extent that explanation is needed in the affidavit directly, it's not there, and I'm not going to push at that. Instead, what I will say, at the risk of repetition, is that that's the very reason why the ruling was asked for by the 25th, so that he wouldn't be in the position of potential non-compliance, because that clarity, and on the basis that Commissioner Baloy has accepted, he wouldn't know the internal working processes, would be given to him. And so when I was reading from the founding affidavit, and I mentioned the answering affidavit that came on the 24th, that was the day before the ruling was originally sought. And if the Commission, in its answering affidavit, simply said, we'll give you the confidentiality pending the determination of the in-camera, then that would have cleared the path to file on the 27th. And so those are the facts about what came before the Commission, and we can't, with all due respect in assessing reasonableness, determine the unreasonableness or the alleged unreasonableness of my client's conduct without those important factual features. Can I just say one more thing, Commissioner Baloy, and then I must make my third concluding remark in response to my learned friend, Ms. Hassan. On my client doesn't rely on threats in the public domain. My client relies, and that's what I understood Commissioner Baloy to have said about things in the public domain. If I misunderstood that.
Yeah, no, you misunderstood me.
Okay.
Yes, I wasn't saying he relies on threats in the public, made to him in the public domain.
Then,
I was saying there is nothing in the public domain that finds, that
breach,
founds.
yes,
Yeah, absolutely.
yes.
That's
Now,
the point I was
then we're ad idem. Then I don't have to say anything further. I understand what you were saying, Commissioner Baloy. Thank you. And then, lastly, in respect of the issue of the threats, I think it's also just important to say it out loud and on the record that 2 witnesses that have come before this commission have been killed. One allegedly killed themselves by means of suicide, but did so after there was an attempt on their lives, and the other was apparently killed potentially or allegedly in relation to what they may not or may not have done here. And all I would say in conclusion, in reminding the Commission of that, is that your job and mandate is about serious issues that go to the heart of the criminal justice system and potential abuse of political connections, criminal connections, and political power, which threatens a huge many deal of interests of people. And where witnesses are dying after coming to the Commission and giving evidence, it's surely not unreasonable in those circumstances that my client uses whatever procedural remedies are available to him to try and get relief from this Commission, to protect him in some way, to make sure he's not subject to the same kind of treatment which is evidenced in his founding affidavit. Thank you, Chair.
Mr. Premier, I don't want to leave it uncorrected that the person who committed suicide testified before this commission. That person was never a witness before this commission.
I apologize.
So I don't want it to be left that way in the public
I
record,
apologize.
because factually
I spoke
correct.
then subject to being told the incorrect thing. I apologize then. And I withdraw that to the extent I need to.
That actually deals with part of my preliminary point.
Mr. Premier, you're going to go into the merits, and maybe just you'll deal with this in the merits. I don't want you to deal with it now, so I can either, in advance of you arguing it, just tell you what my concern is, and then you will deal with it when you argue, and then we can raise questions as you go along. If you look at prayer 3 and 4 of your notice of motion, read with your Schedule A. The effect of it is that the Commission's investigation team must not have access to these documents. The Commission's head of security must not hear this evidence, must not have access to these documents. Now that is problematic because that is the work of the Commission. There is no way you can have a prayer. And our researchers, there's no way you can have a prayer that says the very evidence that's going to be led, your investigator must not hear or know about it. Because their job is to investigate everything that is presented and provide the Commission with facts. So The prayers are problematic, and I will just give you an example with prayer 3. We have, for example, a Mr. Brown Mokgotsi still coming to finish his evidence. If your client, either in his statement or in his evidence, says something that implicates Mr. Mokgotsi, or that Mr. Mokgotsi would like to respond to, Mr. Mokgotsi and his representatives must have access to that in the same way that your client had access to the evidence of Mr. Mokgotsi. And you would have said it's prejudicial to your client if they were not given the evidence and the statement. So it has to work both ways. If your client mentions any person and gives evidence against them, they would be entitled to that. So you cannot have a situation where all papers exchanged in relation to your client's evidence are not disclosed. It cannot just be this open-ended. And then you've had me on the commission staff, especially, on matters of security, for example. The commission's head of security, and I won't go into detail because those are sensitive matters.
And internal processes which we're not aware of, absolutely.
To assess what security arrangements
Sure.
have to be made, he needs to have access to all of this. So you cannot say he must not have access, because how else does he do his job? Do you follow me?
Yeah, no, I do.
Yeah.
Chair,
I'm sorry. Commissioner Kumalo said that that's for when you address the merits, and that think about it and deal with it when you address the merits. I think we've reached. You were to?
Well, that's why I was looking to you to give me direction whether it's now time to address